Due to the various forms of misinformation that has been put out there here on YouTube to include other social media sites by content creators, I have decided to come on here on YouTube today to address a reply that I got from a content creator who goes by the name of the Defense Coalition with regards to, in his words, me putting out misinformation to the general population when it comes to the act of invoking the civil liberty to keep and bear arms under the Second Amendment to the Bill of Rights. In the Defense Coalition response to two of the posts that I created as short stories here on YouTube, he stated that, and I quote, "Bro, this is misinformation. Those conversion cylinders allow it to fire modern smokeless ammunition, and it is a firearm once you put it on." End quote. The Defense Coalition wrote that on March 13th, 2025, a few days ago. And that reply was in response to my post, which was titled, and I quote, "The right to firearms extends to those who have obtained prior felony or misdemeanor convictions." End quote. I posted that particular short video on August 16th, 2024. In addition to that, the Defense Coalition also responded to another post that I published here on YouTube. And in that specific response, the Defense Coalition stated, and I quote, "Once you put a conversion cylinder on that, it is a firearm. You have to be careful because that would violate federal law for a prohibited person." End quote. Again, the Defense Coalition posted that reply on March 13, 2025. And that reply was in response to one of these short videos that I posted, which was titled, and I quote, "Antique firearms can be legally owned by those with prior felony or misdemeanor convictions." End quote. I published that specific short video on September 4th, 2024. Now, getting to the key points to this particular video. One of the things that I've noticed throughout the years is that many individuals here in society, especially those who have become content creators on various social media sites, specifically YouTube, have put information out there for the general population. And I have found that a lot of the information that has been placed out there for the general population to view when it pertains to law is, in fact, incorrect. Now, one of the things that the content creator known as the Defense Coalition have failed to realize about me is that I am an individual who has studied federal and state jurisprudence here in America for over 2 decades. So when I speak about anything related to civil, constitutional, or human rights, everyone, to include the Defense Coalition, should know that I have legal authority to back up everything that I say when it pertains to either statutory provisions or judicial precedents. If the Defense Coalition had read my bio, he would have realized that I have studied law for as long as I just indicated that I have, and that I have a vast amount of law that I have accrued through countless hours of study at my disposal. Now, to counter what the Defense Coalition has said about matters related to outfitting a black powder revolver with a conversion cylinder being illegal, let me direct your attention to what the actual federal statutory provision as it relates to antique firearms state. Now, when you go to Title 18 United States Code, Section 921A3, it defines what a firearm is. And that definition, and I quote, is: the term firearm means A, any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. B, the frame or receiver of such weapon. C, any firearm muffler or firearm silencer. Or D, any destructive device. Such term does not include an antique firearm, end quote. Now, when we look at the term antique firearm, an antique firearm under federal statute, to include most state statutes as well, is defined as any firearm made or manufactured on or before the year of 1898. Clearly, an antique firearm, such as this 1851 Navy Antiquata that I have here, and as you all can see that I have field stripped this particular weapon to give an example of how the Defense Coalition is inaccurate in his assessment to the post that I've made with regards to people with prior felony or misdemeanor convictions being able under federal statute to own these type of firearms. Okay. That's the barrel. It's broken down into, with the black powder cylinder, 3 separate pieces. With the conversion cylinder, it will be 4 separate pieces because of the back plate being separate from the actual bored through cylinder. And of course, that particular revolver is chambered in 38 Colt, also known as 38 Long Colt. All right, now getting back to the statutory provisions related to antique firearms. Now, when you go to Title 18 United States Code, Section 921A16, that's where we will start. That particular statute defines what an antique firearm is. And under that specific statutory provision, an antique firearm is defined as, and I quote, the term antique firearm means A, any firearm, including any firearm with a matchlock, flintlock, percussion cap, or similar type of ignition system manufactured in or before 1898. Or B, any replica of any firearm described in subparagraph A, if such replica, 1, is not designed or redesigned for use in rimfire or conventional centerfire fixed ammunition, or 2, uses rimfire or conventional centerfire fixed ammunition which is no longer manufactured in the United States and which is not readily available in the ordinary channels of commercial trade, or C, any muzzle-loading rifle, muzzle-loading shotgun, or muzzle-loading pistol which is designed to use black powder or a black powder substitute and which cannot use fixed ammunition. For the purpose of this subparagraph, the term antique firearm shall not include any weapon which incorporates a firearm frame or receiver, any firearm which is converted into a muzzle-loading weapon, or any muzzle-loading weapon which can be readily converted to fire fixed ammunition by replacing the barrel, bolt, breech block, or any combination thereof. End quote. Now, I believe that the Defense Coalition was relying upon the latter portion of that specific statute when it was speaking about any firearm which is converted into a muzzle-loading weapon or any muzzle-loading weapon which can be readily converted to fire fixed ammunition by replacing the barrel, bolt, breech block, or any combination thereof. However, what the Defense Coalition failed to realize is that these particular revolvers are not muzzle-loading pistols. They are loaded by either extracting the black powder cylinder from the actual firearm and loading it through each cylinder. Black powder, conical rounds, or ball rounds, to include what most people would feel safer with doing when loading these black powder weapons, either putting some what they call bore butter around the cylinders to reduce any act of a chain fire. So with regards to the statute, speaking specifically about muzzle loading shotguns, rifles, or pistols, specifically this specific revolver, the Defense Coalition was dead wrong in his assessment as to the short videos that I posted on YouTube dealing with these specific type of antique firearms. Now, to move on, this is what they call a conversion cylinder, as I made reference to earlier. A conversion cylinder is considered by members of the ATF to be a part of this specific revolver. Therefore, because it is a part which is considered a drop-in cylinder, one is not replacing any barrel, one is not replacing the breech block, or any combination thereof as depicted in the statute that I just previously read when employing a conversion cylinder into this specific revolver. Okay. Now you have what they call here the alignment pin. Now what most people would do or say is that these particular revolvers, because they did not have any external or internal safety features, to load only 5 rounds instead of 6. That way you have the hammer rested on an empty chamber for safety purposes. So to load these, you just simply put the antique cartridges into the cylinder holes. Once that is done, you align the pin with the little hole here, the alignment pin. So basically you align that with the hole. Excuse me for a second. You put the alignment pin with the hole on the actual firing pin. And keep in mind, these are 6 separate firing pins. And these conversion cylinders were actually designed prior to the year of 1899, which, as you already may have surmised from the statutory provisions that I just read, makes these conversion cylinders legal when it comes to see how simple that was? And what you would do then is turn the cylinder to where it's rested on an empty chamber, lower the hammer. That's simple. Now, me personally, when dealing with these particular antique firearms, I would prefer the conversion cylinder because not only is it, in my view, safer to fire, it also enables the owner to reload quicker. So being that the civil right to keep and bear arms under the Bill of Rights has been under attack by many people in civil service, to include other civilians, for many years now, it puts certain members of society who have obtained felony or misdemeanor convictions, whether those offenses were considered violent or nonviolent, at a disadvantage when it comes to invoking the human right of self-defense. So, for individuals who find themselves under those circumstances, I would suggest and prefer that if anyone chooses to purchase an antique firearm, such as the 1851 Navy Antiquata, that he or she purchases a conversion cylinder to go with that specific antique firearm. Okay, now we know what an original antique firearm is based upon the statutory provisions that I just read to you or quoted. Now, under that statute, there's also what the law considers to be a replica of any antique firearm. And when I cited the replicas, based upon the statutory provisions that I just read, when it says that if it is not designed or redesigned for use in rimfire or conventional centerfire fixed ammunition. Now, what many people don't realize is that the word conventional means technically readily available. You can get something, specifically ammunition, from the formal forms of trade. The thing is, when it comes to the 38 coat round, also known as 38 long coat ammunition, that specific ammunition is not considered conventional ammunition because it cannot be purchased from any gun store, for any federal firearms license dealer. You have to get that specific ammunition from channels outside of the normal channels of commercial trade as defined by that specific statutory provision. It took me over 4 years, literally, to find 2 boxes of 38 coat rounds. I couldn't go to any gun store here in the state of North Carolina to get that ammunition because none of the dealers had it. I had to go to a gun show and speak to an individual who specializes primarily in antique ammunition. And that's where I got that ammunition from. And a box of 38 Coke rounds came up to almost $100. So naturally, as you may have already surmised, I have not fired too many of those particular rounds out of this specific antique firearm. But I have fired enough to know that the firearm functions properly as it was intended to function. Now, another thing about conversion cylinders, there's a firearms company out of Virginia known as Taylor's and Company Firearms Incorporated. And when you actually purchase a replica of an original antique firearm, such as that 1851 Navy Antiquata that I just showed you all for the purpose of this particular video, it comes with a sheet outlining the use of the conversion cylinder. And on that sheet, as it relates to what agents of the ATF thinks about a conversion cylinder, it says, and I quote, "This conversion cylinder is classified as a part by the ATF. No FFL is required to purchase this product," end quote. It is considered a part, primarily because, as I've indicated earlier, antique firearms were outfitted with conversion cylinders prior to the year of 1899. And because antique firearms were outfitted with those conversion cylinders prior to that date, it makes the firearm outfitted with a conversion cylinder an antique firearm still. It doesn't matter if you swap out these cylinders with a black powder and replace it with a conversion cylinder. Still the same thing. And another thing, a lot of these antique rounds, although they do fire or they use black powder, well, not black powder, but they use gunpowder. The gunpowder equivalent that they put into these specific rounds, also known as cowboy action loads, is equivalent to the level of black powder that was used in those firearms prior to the year of 1899, which makes that specific ammunition in those specific firearms legal for anyone to have under federal law, to include most state laws. And I say most state laws because many state laws actually conform with the provisions of the federal statute related to the definition of what an antique firearm is. And to shed a little bit more clarification on what I just said about the conversion cylinders, I'm going to read a portion of what I found out of the gunsmagazine.com website. And this particular form of information was written by an individual known as John Taffin in the year of 2023. And in that, or under that website, Mr. Taffin said, and I quote, "In 1868, Smith & Wesson entered an agreement with Remington, allowing them, Remington, to convert their percussion pistols to cartridge-firing revolvers using a bored-through cylinder, end quote. Did y'all get that? In the year of 1868. So conversion cylinders were around and placed on these antique firearms well before the year of 1899. So when the Defense Coalition stated that I was given false information pertaining to one being able to legally acquire an antique firearm or a replica thereof outfitted with a conversion cylinder that was manufactured well before the year of 1899, which was well within the realms of a person having, under federal statute, the Defense Coalition, from my perspective, has not done his research. And I've met many people like this individual known as the Defense Coalition throughout my years. And one of the things that I notice about these specific individuals is that they tend to not study law for whatever reason that may be. But what they do tend to do is rely upon the statements made by other people, specifically, let's say law enforcement personnel. When he told me in one of his replies to my response to his comments to my post, do a live call with members of the ATF and see what they have to say about what it is that I'm saying as it relates to outfitting a replica of an antique firearm with a conversion cylinder. And my response to the Defense Coalition was, why do I need to contact an agent in the ATF for clarification on a statutory provision in which I have already made myself aware of through the countless studies of law that I have conducted for over 2 decades? I don't need any law enforcement officer to tell me about law when I already know what that law is. What would a member of the ATF tell me under law that is different from what I just read or cited based upon the statutory provisions that were relevant to this portion of this particular post? And what the Defense Coalition also failed to realize is that many law enforcement officers had no clue as to what the law really is. So if I were to go to a law enforcement officer for clarification on a statutory provision, and that specific law enforcement officer misleads me as to what the law really is, that means that I'm going to be put at a disadvantage. That means that specific civil rights that I have or anyone else has to keep and bear arms will not be invoked to the fullest extent of the law. And that is why I oftentimes preach to individuals that they must study law to a great extent to ensure that the civil rights that they have that is protected by the supreme law of the land is respected and protected by those in civil service whom we have placed there to represent our interests under the federal constitution, in which they took an oath to protect and defend from enemies both foreign and domestic. If we are unfamiliar with law, we will not understand when and how a specific civil servant is violating a specific right protected by law. If we are unfamiliar with the law, how are we going to elect or appoint certain members of society as civil servants to take certain positions of public trust when represent our interests under the Constitution? If we don't know anything about politics, anything about the things under the Constitution that civil servants claim prior to being elected or appointed that they're going to do for us under that specific document, if we know nothing about politics and law. So Defense Coalition, if you happen to come across this specific post, which I'm pretty sure you may, you have to understand that I'm not here to attack you, but I'm here to rectify the misinformation that you have given as it pertains to my reputation and character as an individual who has studied law for over 2 decades. And I'm hoping that there is something that I've said or something that I will say in this specific post that will resonate with you and those who think and feel as you do, to where you will eventually change the way that you think and feel and rely upon the actual facts pertaining to law and not relying upon some incompetent bozo who has been elected or appointed to a specific position of public trust. Now, with that being said, we have to realize this, y'all, that not every individual who has been convicted for whatever offense that he or she has been convicted of is actually guilty of the offense in question. We have to also understand that many people who have been righteously convicted for the offenses charged in whatever indictment or information that was filed against that particular individual has been rehabilitated while incarcerated and has come out of a penal institution with a changed heart and mind to where they are now to be considered law-abiding citizens. So we cannot hold one's past criminal history against them for the simple reason that by doing so, we are in breach of the supreme law of the land. Now, when it comes to firearm possession, one of the things or sayings that I have come up with that I felt would resonate with many people by just being as simple as I can is this. And I'm going to speak specifically about the issue related to our civil liberty to keep and bear arms under the Second Amendment to the Bill of Rights. Here's the thing, y'all. We all have a right to keep and bear arms that is protected by the supreme law of the land, also known as the Second Amendment to the Bill of Rights. Any one of us who invokes that specific right protected by the supreme law of the land are in essence in conformity with the law, which makes us, or those specific type of individuals, law-abiding citizens. Any one of us in society who chooses to ignore the supreme law of the land designed to protect an individual's civil liberty to keep and bear arms are, in essence, the criminals, or the more popular term that those in civil service to include other civilians love to use, felons. What I have noticed throughout my years of conducting legal research and examining politics is that those in civil service have manipulated the minds of many individuals into believing that the violation of law is legal, and those who are in conformity with the law are the criminals. And I cannot understand why so many of us, so many civilians who are affected directly by those incompetent decisions made on our behalf by those creeps that we put in civil service, have not yet realized that we are getting the short end of the stick here. People have failed to realize that the things that those people in civil service have done is not for our benefit, but to our detriment. That is why I personally do not believe in any act of gun control. Judicial precedent does not support that. And I wasn't going to say anything about that, but now that the conversation has taken a turn in that respect, I'm going to read to you all a specific case that I found within, let's say, 8 years of my studies of law. And that's primarily because I was assisting other individuals in litigating their cases in addition to litigating on my own behalf. But let me find this for you all. I know I just had it up not too long ago. Here we go. Now, during the course of my studies, like I just made reference to, I've come across judicial precedents primarily out of the Supreme Court for the United States of America, which actually substantiates what I just said about the act of gun control being unconstitutional. I mean, we already know that. When we look at the Second Amendment to the Bill of Rights, it specifically says that the right to keep and bear arms shall not be infringed. Now, the term infringed means encroached upon, ignored, violated, shall not. When we look at the term shall as it relates to a law, the term shall is defined as mandatory. When you see the word may being used in a sentence, that means discretionary. So when the Second Amendment specifically states that the right to keep and bear arms shall not be infringed, it doesn't give any leeway as to everyone respecting that specific freedom. There is not a gray area written in the Second Amendment. And many people say, well, the Second Amendment was meant for the militia. But what people do not realize, or have failed to realize from my perspective, is that the people make up the militia. And when you read the Second Amendment backwards, the right of the people to keep and bear arms to formulate militias being necessary to ensure the security of each and every person within each and every state that makes up this nation. You can't put it no simpler than that. The militia is the people. The people's right to keep and bear arms shall not be infringed. So there's no mistake in what that specific amendment actually entailed or meant. It's just that Many people in society have thrown their own spin on the amendment only to benefit their own personal, political, financial, business, and oftentimes spiritual interests or agendas. It has nothing to do with what's right and wrong. It has everything to do with one's emotional or psychological state at the time that specific matters are brought to the forefront of the public's attention. But the case that I'm speaking about is the case known as United States versus Cruikshank. Citation number 92 U.S. 542, 23 LED 588, 1876. When you turn to page 553 of that specific judicial precedent, which is, for those of you who are wondering, still considered what the judges have declared good law here in America today. Chief Justice Morrison Remick Waite, in writing for the majority of the judges in the Supreme Court at that specific moment in time, stated, and I quote, "The Second Amendment declares that it shall not be infringed, but this, as has been seen, means no more than that it shall not be infringed by Congress. This is not a right granted by the Constitution. Neither is it in any manner dependent upon that instrument for its existence. This is one of the amendments that has no other effect than to restrict the powers of the national government." End quote. When I read that specific judicial precedent, it is clear that members of Congress has no authority under the Constitution to restrict one's access to firearms through gun control. That specific precedent could not be any more simply put as far as I'm concerned. Now, in that specific precedent, what I didn't read is that the judges were saying that only the legislators of a state had the authority under the Constitution to restrict the constituency's access to firearms through gun control measures, because at that time, the judges were under the erroneous presumption that the Bill of Rights, for some reason in their minds, did not apply to members of the state governments, which I have found to be totally preposterous, being that the United States of America consisted of each and every state, known as colonies back in those times. So before any state constitution was ratified, the federal constitution stood in its place. And in order for the federal constitution to be ratified, it took members of each and every state, known as colonies back in those times, to ensure that the Constitution for the United States of America was ratified. So when they agreed to the federal Constitution being ratified, that alone entails that that specific document also applied to them. So I have no idea what the judges back in those times were thinking, because that thinking was totally incompetent. And it had no basis in law or fact. However, in the year of 2010, in the McDonald versus city of Chicago, the judges had a change of heart. You see? And in that specific decision, the judges declared that the Second Amendment to the Bill of Rights applied to the state legislators, governors, and to include judges. And when we look at McDonald versus City of Chicago on page 750 to that specific judicial precedent, to substantiate what I just said about the Bill of Rights also applying to state governments. The judges said, and I quote, "We have previously held that most of the provisions of the Bill of Rights apply with full force to both the federal government and the states. Applying the standard that is well established in our case law, we hold that the Second Amendment right is fully applicable to the states." End quote. In addition to that, and piggybacking off what I just previously said, when you turn to page 754 to that specific judicial precedent, the judges said, and I quote, "The Bill of Rights, including the Second Amendment, originally applied only to the federal government." End quote. You see, that was the form of thinking that these judges had in those times. It originally applied only to the federal government. And to be quite specific, the federal government consists of we the people. The correct terminology that should have been used in this specific judicial opinion would have been national government, because the national government consists of members of the federal government whom we have either appointed or elected to specific positions of public trust. And I like to clarify that because when we equate civil servants as being the federal government, it puts us as the constituency at a disadvantage, because people tend to believe that they do not have any rightful authority in this country over those whom they or we have placed in positions of public trust. People forgot that this is a government for the people, by the people, and of the people. If it wasn't for people like you and I electing or appointing other members of society into those positions of public trust, they wouldn't be in those positions. So that alone should show everyone just how much authority that we have as individuals or on a collective basis, especially when it comes to the invocation of the civil liberty to keep and bear arms. So to reiterate what I've said thus far, to recap, anyone with a prior felony or misdemeanor conviction is legally entitled under federal law to own an original antique firearm chambered in fixed ammunition, or a replica of an original antique firearm that does not use rimfire or conventional centerfire fixed ammunition. And what that specifically means, why that specific portion or statement was actually incorporated into the law, is because many of the replicas of original antique firearms, such as, let's say, the 1898 New Service Colt, originally chambered in .45 Colt, was also designed to be chambered in .38 Colt, which is an antique cartridge, of .455 Webley, which is considered an antique cartridge. But they also went up to, I believe, a .357 Magnum, which we know is not considered an antique round according to the definition of what an antique firearm or ammunition really is. And the definition of ammunition I found to be more suitable in understanding was in the case of United States versus Royal out of the United States Court of Appeals for the Fourth Circuit. But the judges heard a case dealing with an individual with a prior felony conviction having in his possession a firearm and ammunition. Now, the possession of the firearm was not under federal law considered illegal, because it was a firearm that was manufactured prior to the year of 1899. However, the issue arose when the individual had, if I'm not mistaken, 9mm rounds in that specific firearm, which I don't know how that was so, because out of curiosity, I actually put a 9mm round in a 38 Smith & Wesson revolver that I own. And the round just went straight through it. It just went straight through the cylinder. So I don't know what type of handgun he actually owned that could chamber a 9mm round. But anyway, the judges incorporated the ammunition statute alongside the firearm statute. So their reasoning was, if ammunition was manufactured prior to the year of 1899, it is considered antique, therefore not legally defined as ammunition. In addition to that, the judges went further, which is a benefit to individuals with prior felony and misdemeanor convictions, when they said that if the ammunition was specifically designed to be fired in an antique firearm, and that antique firearm can also be a replica, because replicas are also defined under legal definition as antique firearms. So, 38 long coat or 38 coat rounds. They don't make revolvers at present that are chambered for that specific round. Hence, is the reason why it is so hard for an individual to find those rounds. So being that the 38 coat round was manufactured well before the year of 1899, and is specifically designed to be fired in this replica of an original antique firearm, it makes the possession of not only this specific firearm, but also the 38 coat rounds that it is chambered in, outfitted with with this conversion cylinder, lawful under federal statute. The problem is, like I said, many people do not read the law. They do not seek to understand what the law really entails. So they go by what some other incompetent person says about the law. And one of the things that I will bring to the forefront of each and every last one of your attention today is this. This is something that I used to instruct my students on when I taught legal research. And that is this. If anyone ever tells any of you anything about any portion of law, that means that that individual has read or saw what it is that he or she is telling you somewhere in either a statutory provision, a rule, regulation, or policy, or some judicial precedent. And if an individual saw what he or she is telling you about the law, that means that they should be able to direct your attention to a specific statutory provision, a specific judicial precedent, a specific rule, a specific ordinance that specifically entails what it is they have told you that the law actually said. If an individual cannot do that, my advice to my students has always been, and I will convey that to you all today, turn the other way and run. Because if an individual tells you something about law and they cannot direct your attention to that specific portion of law that they are making reference to, that entails that they do not know anything about the law. And if an individual knows nothing about the law and they're trying to convey to you all what the law is, that means that you should ignore what they're saying and move on. Like me, any one of you who comes across this feed, ask me any question about law. It don't necessarily have to be about firearms, but because this is a topic of discussion, maybe that will interest you all. Ask me anything about a firearm, and I will respond to you via direct message here on YouTube or any other social media site for that matter. And I will quote and cite actual legal authority that supports everything that I've stated to you all here today in this specific video. Now, you all may have noticed that this specific video is not like other YouTube channels. You know, when they do takes and make sure everything is said correctly, make sure everything is in order, primarily for time, constraints, as far as I'm concerned. But I chose not to do that today. This is not the original video that I intended to post. But when I got that response from the Defense Coalition, critiquing the information that I have given to people that is supported by law and not what he said it meant or what he was under the presumption that the law was, I felt compelled to get on YouTube to address this specific issue related to the comments that I received from the Defense Coalition. Because I cannot have individuals out here in society telling me, an individual who has studied law for as long as I have, that I am misleading other members of the American population when it comes to the invocation of the liberty to keep and bear arms under the Second Amendment to the Bill of Rights. That is a right that I hold dear. It's any other right, because without the Second Amendment right to keep and bear arms, all of the rights that we have are in jeopardy, whether people choose to believe that or not. So when I speak about civil rights, that means something to me. Civil rights are not to be taken lightly. And those who have been elected or appointed to specific positions of public trust should not be taken lightly either when they violate the very laws designed to protect the civil rights that we have. Whether those civil rights have been created under the Declaration of Independence, the Bill of Rights, the Constitution for the United States of America, to include the Universal Declaration of Human Rights. When those members of society took an oath before us under God and that Constitution to protect and defend it from enemies both foreign and domestic, they need to be held to the standards that they took an oath to be held under. And I can assure you all, me personally, and I believe that I can step out on a limb and speak on behalf of everyone else. When we take our time to go down to these voting booths to elect or appoint specific members of our communities to take certain positions of public trust, we do not do that to allow them to encroach upon the very freedoms that we put them in those positions of public trust to respect and protect. I don't know of anyone who has elected someone to be the president of the United States of America, the governor of a specific state, legislators of a specific state, to include those employed within the United States Capitol. We did not put them in those positions to violate the very freedoms that we have under the supreme law of the land, which baffles me as to why they continue to do it and people allow them to. And that's only because many of us do not know the true authority that we have as individuals or collectively as the constituency, the electorate, the very individuals who have placed those people in positions of public trust have. There are two rights that we have in which we do not invoke enough. And the first freedom, for those of us who are on a more peaceful mission, so to say, is the right to jury nullification. And that freedom enables any one of us to disregard any law that we feel violates the Constitution, the Bill of Rights, the Declaration of Independence, the Universal Declaration of Human Rights, or any other rule or regulation for that matter, and find an individual not guilty or fail to indict an individual for essentially invoking a right that those incompetent bozos in civil service have declared to be a breach in law. The other right that we have, in which those in civil service do not want us to invoke, which we also have a right to do so, is the right of revolution. And that right is mentioned in paragraph 2 under the Declaration of Independence. And basically what that enables us to do as individuals is to alter or abolish those in civil service who become hell-bent on neglecting and abusing us through acts of tyranny. But many people, from what I've come to understand, are not ready for that level of revolution just yet. But it is an option that we have, even though they have created statutory provisions outlawing the act of revolting or the act of invoking the right that we have to revolution. It doesn't make the law right. And because it's technically not against the law, because whatever statutory provision that legislators enact, it must coincide with the Constitution, with the Bill of Rights, with the Declaration of Independence, with the Universal Declaration of Human Rights. Because if it does not, that means that any statutory provision, rule, regulation, or judicial precedent that is established by some civil servant in public office is null and void, because it is in breach of the very laws in which they took an oath under the Constitution to protect and defend. So when those in civil service do not do what's right by us, it is our duty and responsibility to invoke those two specific rights that I mentioned earlier, to ensure that freedom, justice, and equality is able to stand strong within the United States of America. So in closing, every one of you should know, whether you have a prior criminal history or not, the right to keep and bear arms is for everyone. The Second Amendment does not differentiate between who has or has not obtained a prior felony or misdemeanor conviction. And when you really look at things, it is not the individuals being discharged from federal and state penal institutions who are obtaining firearms, going out here in society and committing mass murders with them through school shootings, mall shootings, theater shootings. It is the so-called law-abiding citizens who have not obtained a prior felony or misdemeanor conviction that are going into these gun stores, passing these criminal background checks, obtaining firearms subsequent to passing a criminal background check, who are the ones going out here in society with those firearms that they legally purchased to commit crimes with. The very crimes that are the basis for the current state of gun control in this country today. It is not the individuals getting out of prison. And like I said before, An individual getting out of prison who chooses to exercise his or her Second Amendment liberty to keep and bear arms is in essence in conformity with the law, because the Second Amendment entitles them to that specific freedom. And anyone who ignores the law, who ignores the Second Amendment, and chooses to penalize one of these individuals as a result of them exercising their civil right are the felons that many people in society speak of today. So for everyone with a prior felony or misdemeanor conviction, whether you've been rightfully convicted or wrongfully convicted, whether that offense was violent or non-violent, best believe that people like me are here for you. And not only am I here for you all, I'm also here for the individuals who have not obtained prior felony or misdemeanor convictions in a court of law here in the United States of America. Because what I've noticed is that when we allow the civil liberty to keep and bear arms to be violated by those in civil service who we put there to protect that specific freedom, we open up the doors for that same freedom, as we have seen, to be encroached upon also. They're not just coming for individuals with prior felony or misdemeanor convictions. They are also coming for the individuals who have not obtained prior felony or misdemeanor convictions. They do not want any of us to be in a position to fully exercise the right to keep and bear arms. And the synonym for arms is not just firearms, y'all. It entails bow and arrows, crossbows, blowguns, rockets, grenades. Heck, F-15 fighter jets fully equipped with the armament that they come with. But they have us believing that we are so immature to possess these forms of armament, while yet we are mature enough to put them in certain positions of public trust to where they can have them. How does that make any sense, y'all? It is time for us to start thinking, reading the law, understanding what it really means, accepting it for what the words truly entails. Only then will we all be in a position as individuals to come together collectively to hold those tyrants in civil service accountable when they subject us to acts of neglect and abuse, when encroaching upon the very laws designed to protect the civil, constitutional, and human rights that we have by virtue of being human beings or citizens of the United States of America. I hope that there's something that I said today that resonates with each and every last one of you. And like I've mentioned earlier, if you have any questions pertaining to anything that I've mentioned thus far in this specific video, or any other post for that matter, feel free to send me a DM. Feel free to subscribe to the channel, because I do have more in store. I'm actually working on a specific publication for YouTube that's truly going to educate each and every last one of you to the rights that we all have to keep and bear arms. And I'm going to put up legal authority on the screen so you all can read along with me, because I found that people tend to believe more when they can actually see something. But because this issue was pressing to me, I did not do that today for this specific video. But I have offered to inform you all of whatever judicial precedent or statutory provision that I made reference to here in this video, if in fact you choose to want to know more about it. So I can actually quote it to you, send you the statute, however way that you all would like for it to be submitted to you, in order to put you in a better position to understand what the law really entails, and to clarify the things that I've mentioned thus far in this specific video to you. But until then, I hope all you have a nice day or night, depending on where you are in this world. And I want you all to stay safe. I want you all to invoke the civil liberty that you have to keep and bear arms, because without arms, none of us at present are truly safe.